Hi, good afternoon. Brad Miller at ComplyAuto. It's late September, and we're talking a little bit about the CARS rule. There have been a few things that have been happening in the world. For those of you who don't know, who've been under a rock for the last few years, the CARS rule is a rule that the FTC passed a few years ago, but was interrupted in its enactment by the lawsuit brought by NADA. NADA sued the FTC seeking to enjoin, stop enactment of the final rule. And it's been pending before the Fifth Circuit for the last sort of year plus. And oral arguments are expected next month in October, and a decision from the Fifth Circuit is expected likely in a few months after that. There's no real deadline for when they have to issue an opinion, but it's believed that it will likely be within sort of a 3 to 4 month time frame after that. Now, today, NADA issued a driven guide on the CARS rule, on what they call the vehicle shopping rule. And it was co-authored by us at ComplyAuto, myself and a colleague of mine, Mark Sanborn, along with some of my friends and former colleagues at NADA, put this guide together. And I would encourage you to go download it and take a look at it. Whether the CARS rule passes or not, it's something you should at least be aware of. Remember, the FTC's position, although a somewhat dubious position, is that the CARS rule is really sort of reiterating what the current law is with respect to advertising F&I practices in many ways. So it's worth a review. Now, again, the CARS rule is not finalized today. It may never be. The hope is that NADA wins their lawsuit, and then the FTC goes back to the drawing board and does a rule right or rethinks the need for a rule. But whether it happens or not, you really need to understand what the FTC is thinking in terms of compliance for another reason, and that is that in lieu of the CARS rule, there's really been an uptick in enforcement actions, both at the state and federal level against dealers. And there's some themes emerging. They are going after advertising practices, largely price advertising, prices that don't reflect the final transaction price of the vehicle, whether it's dock fees, other fees, whether it's optional add-on products that consumer believes are mandatory. Their allegations are that dealers mislead consumers into believing they have to buy F&I products or other add-on products that are not required. Or fair lending practices, which tend to be sort of one of the allegations in all these claims. Now, remember, these are allegations. These dealers that get these enforcement actions, both at the state and federal level, really, you're stuck in a trick box. I mean, you can't. It's very difficult to fight back against these allegations. So the fact that they've settled these cases, sometimes for many millions of dollars, certainly doesn't mean that they did anything wrong necessarily. It just means that they were the ones at the unfortunate end of this enforcement action. But dealers should be aware that this really is happening. Scrutiny is increasing tremendously, and you really need to know what's going on with your advertising and F&I practices in your store. So take a look at the NADA guide. Call ComplyAuto if you have some questions. We've got tremendous tools, including the Guardian tool that we just are releasing now in many states that is both state and federal law compliant, that will help you to really get a better sense of what's happening in your advertising and also in the F&I space. And we can tell you more about that if you call ComplyAuto. So wanted to let you know what's happening. Download the guide from NADA. Take a look at it. Make sure you have it. Stay on top of what's happening with the CARS rule, and stay on top of what's happening with your advertising and F&I compliance in your stores. Call us if you have any questions. Take care. Thank you so much.